SVC Media.
Welcome to the iGaming Daily podcast, analysing the news from the betting and gaming industry all over the globe, supported by Optimove, the #1 CRM marketing solution for the iGaming market.
Player protection is one of the most important and most discussed topics in the iGaming sector. Ensuring that players are protected from both problem gambling and other financial threats that can occur whilst betting online is essential for the long-term sustainability of the industry. But how can operators protect players' funds? And what can we learn from a landmark Danish case in which so-called segregated funds were still classed as part of a bankrupt operator's estate? Welcome back to iGaming Daily. iGaming Daily is supported by Optimove, the creator of positionless marketing and the #1 player engagement platform. If you're heading to SBC Summit in Lisbon, mention iGaming Daily when you visit Optimove at stand A555 to get your first month for free. I'm Charlie Horner, and joining me for this today are Kees-Jan Avis, Managing Director of the EM Group Netherlands, and Henrik Norsk Hoffmann, Partner at Nordic Legal. Kees-Jan, Henrik, thank you very much for joining us today. How are you doing?
I'm fine. Thank you very much, Charlie. Happy to be here.
I'm also doing quite well, and I think this topic is particularly interesting, so I'm really happy to be able to participate in this debate.
Yes, a really, really interesting one, and we'll dive into this and much more. But before we do that, I'd just like to get a brief introduction for both of you, just so our audience know you a little bit better before we dive into things. So, Kees-Jan, maybe we'll start with you.
Yes, happy to do so. As you mentioned, I'm the managing director of EM Group in the Netherlands. Basically got introduced into the online gaming industry as per 2021, the moment that the Dutch market regulated the online gambling business. I used to be active in the financial services industry just on a regular basis, but with the introduction of the Dutch licensing environment, basically got introduced to the interesting topic of safeguarding player funds, which is a requirement in the Netherlands as well. And love being involved ever since.
And Henrik, how about yourself?
I'm a Danish licensed attorney, and I've specialized in gambling law since 2002. So I've been in this industry for quite a while. And in 2017, Morten Lande, Maria McDonald, and I founded the Nordic legal law firm, specialized as a boutique firm in gambling in the Nordics. And we recently expanded into Finland in the expectations of the new market there. So I've been working with gambling law for more than 2 decades, and I believe I've assisted the majority of the license holders on the Danish market get their license and to keep it.
Mm-hmm. Fantastic. So all of the expertise with us today to dive into this one, because it's a really interesting one. So the Hansen versus DK gambling case in Denmark, it revealed that even segregated player funds can be treated as part of a bankrupt operator's estate when separation isn't truly independent. So Henrik, I'd like to come to you first. What went wrong in the Hansen case?
Well, for the DK gambling, what went wrong was they followed the instructions from the Danish Gambling Authority, to be a little bit naughty, putting it that straight. There is, in my opinion, a misunderstanding of how Danish insolvency law functions when separating funds and taking them outside of the insolvency estate. And the DGA has introduced an administrative practice that requires the operator to consolidate both the player funds account and their daily operations accounts on a daily basis, so that the player funds, the segregated account, is exactly the same as the total liability towards the players at least once a day. The problem with that process is that the second after the consolidation has been executed, the numbers don't match anymore. On top of that, which became apparent in this case, the payment systems are a lot more complex. It's not like the players are depositing straight into the segregated account. They pay basically through a payment service provider who then maybe once a week make transfers into the operating account, but they are cutting out their fee, and then the operator takes from the operating account into the segregated account. And that, in this case, made it impossible to follow the funds from the player all the way to the player account. And consequently, it was found to be part of the insolvency estate. The regulations in Denmark actually allow for more flexibility for the operators to have a better protective system than the DGA's current administrative practice and their interpretation of the regulation.
So the court ended up ruling that the segregated funds were part of that bankruptcy estate. So is that an issue with the Danish regulations? Is that an issue with the operator? Is that or is it those sort of payment service providers that you mentioned earlier?
Well, the regulations are not necessarily at fault. The biggest problem with the regulations is that they require that the operator is the only one who has ownership and access to the segregated account. And that in itself makes it difficult in an insolvency situation to say that they are outside of the estate, since the estate ultimately was the only one with access to control that account. But the DGA's interpretation has made it even more difficult to do that because of their process with the daily consolidations and not considering two things. First, that Danish insolvency does not apply, for instance, to a Maltese company. And secondly, that the banks, they don't run every day. They're closed on bank holidays and on weekends. So if you consolidate on Friday morning at 10 a.m. and the company is declared bankrupt after an extended weekend, say Easter weekend, on Tuesday at 9:30, the numbers are never going to be able to match because it's been operation for almost 4 days since the last consolidation was registered by the bank.
Mm-hmm. And Kees-Jan, this, while you focus mainly on the Netherlands, this topic is still well within your expertise, working in sort of player fund protection. So what's your reading of this case? How do you assess what's happened here?
Well, I see a few things that trigger various issue. I don't think there's a clear understanding from the various angles of the legal system that applies. One can adhere to their gambling regulation, but as the Danish case evidenced, it might be different from an insolvency practice. And I think at the end of the day, the insolvency is guiding the estate and how it's being handled. At the same time, the current situation doesn't cater for the fact that player funds by definition are volatile. Each and every second players play, and there's a game result, and there's player withdrawing and contributing funds to their player account, something that's also not easily incorporated in the current system. Although the overarching aim I see in every territory is that the player protection being organized in a way that the segregated funds, so those kept on the player's account, are kept independent from the risk-bearing capital or any risk-bearing funds that the operator has in its own books and administration. And I think that's where the current setup in the Netherlands caters for very well, actually.
Mm-hmm. And I'm eager to get both of your thoughts on this, because I guess this case could really dent player confidence in fund protection, because if one has funds in a gambling account and that operator goes bust overnight, my funds aren't necessarily protected, as demonstrated in this case. So is this going to have an impact on that long-term player confidence in fund protection? Kees-Jan, maybe we'll come to you first on this one.
I would believe so, because I think that predictability is key here, and therewith also the confidence in the system that has been set up caters for scenarios which are negative for the operator, for instance. And I think this becomes increasingly important in an industry whereby rules and regulation are enhancing and tightening in relation to operators, whereby having a successful online gambling business becomes more and more challenging, which automatically enhances the risk on operators stepping out of the market or even going into insolvency. Yes.
And Henrik, would you like to add anything on this one here?
Yeah, but particularly for my own jurisdiction in Denmark, I think this is critical. It's now the second insolvency case we have, and it's the second time where the players don't get their money back. So yes, it shakes player confidence in the system considerably, I would think. But in the case in Denmark, it's ultimately fixable, fairly easy. And it's surprising me that there's so little emphasis on this. They introduced the SAFE system. It's a data vault system that records all data on transactions and gameplay for only the DGA to look at for this exact purpose, namely to create player trust in the system. And then they have an area like this. I mean, granted, it's the second bankruptcy case in now 13 years of operation. So it's not like it's a daily event that an operator goes bankrupt, but it does happen apparently. And then protecting the players' funds could be achieved with a few tweaks on the regulation. And yet, even after this decision in the district court, there's not even a debate whether to change it or not. Everyone is waiting for the appeal case, which is going to be heard in court next month. So it does injure the player trust in the system. And if that is gone, the whole market will collapse.
Indeed, yes. And I mentioned it at the top of the show that these kind of things are critical for the long-term sustainability of the industry. I guess if you don't have any players, then there's no industry to sustain. But Henrik, you mentioned that there are fixes. Kees-Jan, how does true independence in fund separation work in practice? So essentially, how can we look forward and try and fix this before we go to a quick break?
Yeah, well, I think two things are key in order to really separate player funds from the operational capital of operators. And those two elements are, it should be outside of the financial and legal environment of the operator. So it should really be independent. And in addition to that, it should be independently managed. There should be no control mechanism available for an operator to touch those funds, because by means of them being able to touch those funds, you risk becoming part of an insolvency procedure, and you also risk mismanagement of those same funds by that operator itself.
Excellent. Well, Kees-Jan, Henrik, we'll take a short break and we'll come back and we'll continue the discussion.
SBC Leaders connects the gambling industry's top-tier operators and associations to share the best ideas, collaborate on solving the biggest issues, and push innovation throughout the betting and gaming industry. If you're an operator and want to join the discussion, visit sbcleaders.com for more information.
Welcome back to iGaming Daily. I'm joined by Kees-Jan Avis, Managing Director of EM Group Netherlands, and Henrik Norsk Hoffmann, Partner at Nordic Legal. We're talking all about player segregation, player fund segregation and player protection. So, Kees-Jan, I'll come back to you for this as our resident Netherlands expert. What are the KSAs, the Dutch regulator? What are their requirements for player fund protection?
Well, the basic requirements are that it should be kept apart and separate from the risk-bearing capital of an operator that has a license in the Netherlands. With the opening of the market, basically the KSA provided guidance on what are accepted methods, and that used to be the issuance of a bank guarantee or a third-party account. Funny enough, those two methods did not really work out because banks are hesitant to issue a bank guarantee towards a counterparty which are unknown at the moment that the bank guarantee is being issued. Apart from the administrative burden of the huge number of players that need to be paid out if the guarantee is called, and the third party accounts, although it should be facilitated by banks in the Netherlands, it's not something that is very common. It's not a market practice, and it's definitely not applied by banks in relation to the gambling industry, which is perceived as a high risk industry. So the third option that was available within the KSA regulation is a foundation model. And the foundation in the Netherlands is a specific legal entity that is already known for decades to function as asset protection or asset separation vehicle in financing structures. But basically, it's an independent orphan entity in the Netherlands that holds funds for a specific purpose. And in this purpose, it's specifically holding funds for the event that an operator goes bankrupt and players still have a claim towards that operator. So if such scenario matures, then a player can come to that foundation in order to request his player funds rather than step in line with an insolvency procedure and claim it from the estate.
Mm-hmm. And Henrik, is this something that we see in other jurisdictions, or is this mainly a Netherlands-specific piece of regulation?
I've actually only heard of it in regarding to the Netherlands regulations. The British regulations, they leave it more up to the operator to sort of set up a system that protects the player funds in case of insolvency, and leave it up to normal competition for the players to see which system they trust more. And in the end, that approach is probably, at least I don't think we'll see that in the Nordic countries, that it's putting too much trust in the operators and leaving too little influence on the regulators. And as Kees-Jan said, there are simple methods that would require the banks to cooperate. The problem for this industry is the banks don't want to cooperate. They don't really want to have anything to do with the gambling industry. So escrow accounts and other similar solutions are probably great in theory, but I don't think they'll ever work in practice. So we need to come up with a solution that allows for the operator to be inventive. Experience has told me that reality almost always exceeds imagination in what's going to happen. So, but from an insolvency law point of view, to protect the player funds, I think it's crucial that you take legal ownership and control away from the operators if you want to segregate player funds and keep them separate from an insolvency state, should it go that way.
Mm-hmm. You said there that there's lots of trust that has to be placed in the operator. I guess one way of not necessarily removing it in entirety, but I guess diminishing that trust, the trust that is required in the operator, is by introducing third-party involvement. So Kees-Jan, why is the third-party involvement so important for genuine separation?
Well, as I mentioned, and Henrik mentioned as well, the control element of it is key here. You don't want to risk misuse of these funds, and to that extent, it's comparable to a bank or a trading platform, whereby there's great confidence in a system whereby a player or a consumer gives his own money to someone else, whilst it still is its own money and funds that are at stake. And I think the same applies here in this setting as well. So the control element is key here in order to take it outside of control of the operator. And the third party involvement could also be of benefit in the event that an actual insolvency takes place, because such a third party will also make sure that any distribution to players in light of the insolvency will be made on a substantiated basis, either based by information that players provide or that operators and the administration of operators provide. So the actually handling of the insolvency is also an administrative task that would be for the third party that is involved.
Mm-hmm. Yeah, and there are significant challenges that operators face, doing this, and this is why these issues do rise. So what are those challenges that operators face? So when they're trying to establish compliant fund separation?
Well, I think one of the main challenges is aligned with what Henrik already mentioned. It's simply a matter of fact that the gambling industry is not seen as a traditional industry. It comes with high risk if it comes to financial services providers. So they don't have access to the same solutions and mechanisms that other markets might have, because gambling is seen as high risk, and therewith the risk of operators going into a solution that might help them obtain and maintain their license, but which might not be adequate for the actual challenge itself. I think that's one of the key risks that's at stake here.
Mm-hmm. No, absolutely. Henrik, I'd love to bring you back in on this one. How can operators ensure that they meet regulatory requirements effectively? I guess specifically in the context of player fund segregation.
For Denmark, that is exactly the problem. They all try to follow the DGA's administrative practice and requirements, which in my opinion, are not founded in the regulation, that there's no legal authority for the current system. But the operators have to play along, otherwise they won't get the license in the first place, and they won't be able to keep it because they don't follow the administrative practice required by the DGA. But we should not forget that the operators are, if not more interested in trust in the system than the regulators, and at least at the same level. And so you're between a rock and a hard place in the Danish system as it is right now, because if you follow just the regulation, then at least the operators would have some possibilities to be a little creative to see if they can find a better way to protect the player funds under the insolvency law of the country where they incorporated. But because of a misinterpretation of Danish insolvency law, and the fact that the regulations and the administrative practice, not to forget, are based on the assumption that Danish insolvency law applies to everybody, which it doesn't. So just in Denmark, just follow the regulation would actually allow some operators to have a better protection system than the current one, which is forced on the operators by the Danish Gambling Authority.
And Kees-Jan, how about in the Netherlands? How can operators sort of manage to keep compliant, essentially?
Well, the Dutch regulation is quite clear on the solutions that are catered for in this matter. And as a matter of fact, the KSA has, I think it was last week, announced its new policy rules, whereby the foundation solution is basically the only surviving solution if it comes to safeguarding of player funds. And I'm confident that if not all operators are very willing to adhere to whatever is required under the regulation, but I think we established that it's not always the regulation that meets the requirements that come and are faced in practice. So I think it's also very much a call towards the regulators themselves, that they should be very aware of the fact that their regulation might, by means of the words and the intention, might be correct, but they should be open for slightly alternatives that would result in a better outcome overall, rather than being very strict to the letter of the regulation itself. And as such, I think jurisdictions can learn from examples in other jurisdictions. It could be the solution that is now functioning in the Netherlands, but definitely also the experience that there is in Denmark in relation to the insolvency that has taken place. We claim to have a European standard, so let's make sure that European standard can be used in a variety of European jurisdictions that face the same challenges here.
Mm-hmm. And finally, very, very briefly, because we're very close to running out of time, what's the number one thing that operators should look for when establishing fund separation mechanisms? Well,
if you ask me, I would say apply for a setup that is currently working very well in the Netherlands, and try to persuade your local regulator that such setup basically applies to the real separation of safeguarding of player funds outside of the control and the assets, the risk-bearing assets of an operator. But that requires a bit of guts and discussion with the regulators, I suppose.
Mm-hmm. And Henrik, what's the number one thing that we should be looking out for?
The most important thing is that somehow the operator need to remove their direct influence on managing the account with segregated funds in it, so that it cannot be abused to be taken into day-to-day operations. Second on that list would ultimately be to see if they could get rid of ownership as well with a third-party solution or similar. But it's the control that makes it necessary, at least under Danish law, to be able to follow the funds amount for amount from the player through the whole payment processing system and into the segregated account. And that's practically not possible. And when that's not possible and the operator has full control, and by regulation is the only one who's allowed to have any control of that account, then there you have the problem, because the control is there and the transparency of the money flow is not.
Mm-hmm. Fascinating. Henrik, Norsk, Hoffmann, Kees-Jan, Avis, thank you very much for joining us today. Thanks for your insights. And thank you to the audience for tuning in to this episode of iGaming Daily, and tune in tomorrow for another episode.
Thank you for listening to today's iGaming Daily podcast, supported by Optimove, the #1 CRM marketing solution for the iGaming market. If you want to find out more about some of the subjects raised today, feel free to explore any of the sites in the SBC News network, or check out the latest edition of the SBC Leaders magazine. Happy reading.